I'll call the meeting to order. We're starting at 10 o'clock. Could we have a roll call, please?
Chairman Loper,
Present.
Vice Chairperson, Member Cardin, Member Clapp,
Present.
Member Ward.
Present.
Chairman, we have a quorum.
And just for the record, Ms. Clapp is acting as chair since she's in person.
I'm the only one here. All right, we'll start. We'll start with the announcements. This meeting has been noticed in accordance with Open Meeting Law ARS 38431. Agendas are available within 24 hours of each meeting in the Maricopa County Planning and Development Office and are available on the Planning and Development website 1 week prior to hearing at www.maricopa.gov/planning. With respect to hearing process, cases will be considered in the order they appear on the agenda unless otherwise agreed to by the board. For each case, the applicant will be given a set amount of time to present their testimony. Any witness wishing to give testimony on a particular case shall notify the board of such interest. This shall be done by filling out a speaker card here or registering desire to comment as noted on the published agenda. Also, at the appropriate time for each case, the chairman will ask those attending in person and online who wish to speak to a case to raise their hand by clicking on that icon on the webinar screen. Staff will provide the chairman with the names of persons who have registered and noted desire to comment and those registered participants who have raised their hand. The chairman will call on each named participant one at a time. Such testimony shall be limited to a maximum of 3 minutes. However, the actual amount of time allowed for testimony shall be at the discretion of the board chair. The chairman will conduct the hybrid in-person and virtual public hearing according to the bylaws and according to the rules established by the chairman regarding public comment. Votes will be done by roll call vote only. The chairman will verbally identify the specific members responsible for all motions and seconds. So we'll move on to the minutes for the May 16th, 2024 hearing. Are there any comments from the board members regarding the minutes? Okay, then the minutes are approved. We have no consent agenda items today, so we'll move on to the first regular agenda item that we will hear today, which is BA 2023066, the Hobbs property. And we will have a presentation, I believe, from Andrew Lorenzen.
Madam Chair, before before Joseph presents, case BA 2024-014 is an appeal related to wholesale nursery versus retail nursery. That's continued to July 18th for the record, and there's no action necessary from the board.
Thank you. So the next item is the Hobbs property item.
BA 2023-066, the Hobbs property in District 3 are variances to a north setback and west setback for property at 3040 Summit Walk in the Anthem area. There are aerials in the staff report, and I believe this is existing construction without permit, and I believe one of the concerns from the property owner is that his HOA does not allow detached accessory structures, but that's not a zoning matter. You'll see the findings are in paragraph 16. Should you find that there is warrant for the variance, we suggest it be approved, memorialized via items A and B in paragraph 17. And I'll try and answer any questions you may have.
Thank you. Is the applicant available to present the case?
No questions.
That'd be great. Yeah, thank you. Good morning.
For your
Pardon?
record, my name is Taylor Earl with the law firm of Earl and Curley. Our address is 3101 North Central Avenue in Phoenix. Good to be with you today here on behalf of John Hobbs, who is here in case you have any questions that exceed my knowledge. But thank you for being here, and we appreciate the time that we have to present this. So I'm going to press the gold button here, and there it goes. Okay, so give you just an orientation of where this project is located. It's up in the Anthem area, kind of north in the North Phoenix area, and obviously unincorporated. And we'll zoom in here a little bit more. There we go. So wanted to show this. This is up against a mountain range, up against state trust land property. And that'll become relevant as we talk about the rear setback. Oftentimes when we talk about rear setbacks, we have, a residence or something else behind. Here, we're up against open space. This is the photograph of the Ramada. It is a pre-existing structure. The story on that is that Mr. Hobbs hired an individual contractor to construct it, but as part of that, to obtain permits. And unfortunately, that contractor did not do what he was supposed to do, did not obtain permits. And this was true of some other work that was done on the property. And so Mr. Hobbs came to us and asked for our help in sorting through a lot of those issues. And we appreciate the county staff helping us work through a lot of the other issues that were done. And sometimes these property owners, they hire a contractor expecting that the work will be done as expected, that the permits will be obtained, and sometimes they're just not. And so to his credit, Mr. Hobbs has worked and spent time and money to make this right. And this is the final piece that if we can get this variance approved, that'll allow us to obtain the permit. And then we'll be able to bring the property into full compliance. If you look at the photograph here, you'll see that there's nothing particularly odd or intrusive about this Ramada. What's interesting about this photograph, if this structure had even, call it a 6-inch separation between the house and the structure, its exact location would be permitted under the zoning ordinance. So it's kind of an odd situation that the property has, that there's really nothing, again, sort of offensive or in a place where it otherwise couldn't be in this photograph. This is a photograph of the site, and I'll zoom in a little bit more, but what you'll see is that you can just tell by looking at this photograph that the principal structure has taken up a large proportion of the site. And so that is because of two main things. Number one is that this property, through different zoning approvals, has a decreased lot size. It is a small lot for its zoning district. And it also has increased lot coverage, meaning that the building envelope, the primary building envelope to which that Ramada applies is full. And there isn't a place for it to be placed within the primary building envelope because of things that weren't attributable to Mr. Hobbs, but rather pre-existing conditions on the property. So as I mentioned, he contracted to have the amenities built. They were built without permits, unbeknownst to Mr. Hobbs, and the Ramada was built in violation of code and zoning. And so again, this is what I mentioned earlier. This is this portion here. If you had sort of a small detach between this and the principal structure, would be considered an accessory structure, and then could stay in that exact location, having 3-foot setbacks. But because it's attached to the building, it becomes part of the primary structure and then has to meet the primary building setbacks. And so that kind of creates the oddity here. So again, as an attached structure, it does not meet both the rear yard building setback and the side yard building setback. And so that's the purposes of the variance today, is for us to seek relief from those two particular standards. But as a detached structure, it would meet all setbacks in the exact same location. So conceptually, although the variances are a reduction to the rear and side setback, conceptually this can be thought of as an allowance that an accessory structure be affixed to the main house. Effectively, a Ramada is an accessory structure. We know that. They're not uncommon. Pergolas are commonly added to people's backyards in Arizona for shade. And so really the variance can be thought of conceptually as an allowance that be simply attached as opposed to be forced to have a 6-inch or foot detach. Effectively, this is what it might look like. You might have a post there and you might have a separation gap. So we're simply asking for a variance to allow that structure to be attached to the house in order to be more structurally sound to not have to put another post in. And we don't see that there would be any real benefit to having that extra separation. So again, this is from an elevation standpoint. We can again think of it as, this is also for competing authority, I'll just note. This was referenced earlier, but I do think it's important background to understand that according to, under the county's rule, the subject structure is okay only if it's detached. Unfortunately, the subject structure is only okay if it's attached according to HOA rules. And while that the HOA rules are not necessarily applicable to the county focuses on its ordinance, it does put the property owner in a difficult situation where you have two masters you have to serve. And in this structure at that location needs to be attached to the building in order to comply with the HOA approval and its HOA standards. And yet at the county, it needs to be detached in that location. So you have sort of this competing authority. And it's hard to read. No man can serve two masters. I throw a biblical reference in there just for entertainment value. But that's kind of the situation, right? He's sort of pulled in two directions. And so again, here you have HOA rule to require the structure to be attached. County requires a separation, whatever that is, 6 inches, foot. And also, I'll just note just in case anybody has this question, this is as a fully metal structure. There's no issue here with building code or separations or things of that nature, which you might think, well, isn't there a need to have a separation? There isn't. We meet all our fire codes. So again, we don't see any functional purpose to force it to be detached if it could simply stay in that same location. I do want to focus in on this to talk about this is what I alluded to earlier. So there's really no room left in the primary building envelope because this is attached. Therefore, it triggers the need for it to meet primary building setbacks as part of the primary structure. Unfortunately, in doing that, you can just look here at the orange outline. That is the primary building envelope. You might have thought I was trying to draw the outline of the building, but no, that is the outline of the primary building envelope. And you can see that this structure is almost fully into all corners of that primary building envelope. And that's because of two main things that are in the standards table, which is that you have a reduced lot size. You have approximately half of that size that is allowed into this R118 zoning district. And then in addition to that, you also have a reduction, increased lot coverage. So the combination of those two elements essentially shrink any area left in the primary building envelope. So you have a small lot relative to the zoning district. And so as the variance test looks at, it looks at the conditions of the zoning district, and it looks at the conditions of this property as it relates to those standards. And so you have a small lot, although it's not a 4,000 square foot lot in that sense. The ordinance the variance test looks at whether it's small relative to the rest of the district. And so in this case, you have a lot that is approximately half the size of what would otherwise be permitted, or would be the minimum lot size within that zoning district. So you have a small lot, and then on top of that, you have increased lot coverage. And so before Mr. Hobbs ever purchased the property, you had this situation where you built into this space. So as you come in and say, well, not uncommon to want to have some shade in Arizona, you have a scenario where there really isn't a place to put it. You can see in the top left corner of that, that's the structure there in the top left corner of the screen. You can see that while it is outside of the primary building envelope, there really wouldn't be another place you could put it on the property where it could fit within the primary building envelope. Now, if we felt that we were doing something egregious or that this was a very large ramada or something, you might say, well, just make it smaller and shove it into that corner. But you can see here, there really wouldn't be an opportunity for that. And so again, technical analysis, these are the two requests: variance to reduce the rear yard from 3 to 3 from 21 and to 3 from 7 on the side. Again, so special circumstances, walking now through the test, I've alluded to all of them. I'll just put them in formalize them here. So we don't see any benefit to the separation to force this property, the ramada, to be removed from the house. So it's sort of an odd circumstance that would bring it into compliance, but there's no benefit to a neighbor. There's no benefit to the county. It's just sort of arbitrary. It becomes sort of serving the ordinance versus serving sort of the practical circumstances. Again, this is sort of, okay, this is okay, not okay, okay, not okay. It's just sort of an oddity here. Again, you also have this as sort of conflicting rules where you need to have it attached in order to comply with the HOA. You need to have it detached in order to comply with the county. And then another one here, just a throwback to the 1990s toy of Stretch Armstrong. Mr. Hobbs has been pulled in multiple directions because of that conflicting ordinance. Special circumstance 3, again, no room left in the primary building envelope. There's really nowhere else to relocate this structure. And then, as I alluded to at the very beginning of the presentation, you have this situation where to the north, we don't have a property owner. We have state land. It's this big open space, so there's nobody that would be up against that. And no roadway, no building, no neighbors. If we talk about enjoying reasonable property rights, given what Arizona has in terms of sunny days, shaded spaces are important. I think everybody here appreciates that as living in Arizona. So again, nothing here that's an odd creation or that he's doing something that's out of the ordinary or trying to jam in the site. These are just normal requests to have shade in one's backyard to enjoy the pool area with his family. We don't see this as being materially detrimental, again, because of the open space you have, because technically it could be at that same location if detached. It's also relevant to note that we have support of the neighbor. So while we do have a neighbor to the west, we have the support of that neighbor to the west, and then additional support from neighbors across the street. We did reach out to the property owner to the east of the site, although that's not where the structure is located, is an investment property, and just never were able to hear back from that property owner. So again, some excerpts here from the support letters. This is to the west. The proposed variance is needed, and I support the approval of their variance request. And then from the south, I am a resident of the surrounding community, and I support the variance. So again, Mr. Hobbs has tried to act in good faith on this. You had it contracted to have amenities put into the backyard, said that they would obtain permits. The client expected the permits would be obtained, and they were not. He needed HOA approval. He obtained that approval. The zoning compliance is needed, and he reached into and executed a compliance agreement with the county in order to get these things taken care of. So Mr. Hobbs has tried his best to remedy the situation. There was some confusion that happened also during COVID, so there was certainly delay. But Mr. Hobbs, again, brought us on board to try to bring this into compliance, and we've worked on several things with staff, and this is the final piece of that we need to bring it into compliance. So this would effectively allow us to bring this final chapter on this case that we've worked on for a while to close. So in closing, I would just note that we do think that there are special circumstances. The size of the lot is a physical condition, that there just isn't really another place to place the structure. Because of the reduced size of the lot, we think that meets the condition for a physical condition on the lot that is peculiar. It's not imposed by the applicant himself. We don't think there's anything unreasonable. In fact, we think this is reasonable property rights to have a structure of a normal size to be able to enjoy with your family. And given the support that we have and the surrounding condition, we don't think there'd be any negative impact on the surrounding community. So with that, we would ask the board to hopefully approve these two variances and allow the structure to remain.
Thank you. Do any of the board members have any questions for Mr. Earl?
None by me.
Apparently not. We have no questions. Do we have any citizens, residents that want to speak to this particular case? Anyone online?
There is no one online wishing to speak.
Okay, fine. Thank you. Then I will close the public portion of this meeting. And I'd ask each board member to make any comments that you want. If anyone has a motion, please provide it.
Madam Chair, Member Loper, if no one else wishes to, I'll make a motion.
Okay, we have a motion from board member Loper to approve this case. Is there a second?
Second.
We have a motion and second. All those, oh, sorry, we have to do a roll call. Roll call vote, please.
Member Ward,
Yes.
Member Loper,
Yes.
Chair Clapp.
Yes,
Chair, that's a motion for approval by a vote of 3-0.
thank you very much. Thank you. Next case is BA 2024-013. Who's presenting on this case? Mr. Mueller?
Correct. Thank you. BA 2024-013, the Kupasami property. Next slide, please. The subject property is located east of the southeast corner of Greenfield Road and Twin Acres Drive in the Queen Creek area and is within the Rural 43 zoning district. Next slide, please. The request is to allow a 40,429 square foot lot where 43,560 square feet is the minimum permitted. Staff notes that the property owners obtained the parcel as well as the parcel to the due east when they were a single property. The combined property was just about 1.9 acres in size, which is not large enough to yield two properties compliant with the Rural 43 lot area requirements. Regardless, the property underwent a minor land division, creating the substandard lot area on the subject property, as well as the 1 acre parcel to the east. The property is relatively flat and is of regular rectangular shape. Staff was unable to identify any distinguishable features on the property. If the board finds the applicant has satisfied the statutory test and has stated its findings on the record, the grant of this variance will memorialize a minimum lot area of 40,429 square feet for APN 304-70074E. Thank you. I'm happy to answer any questions.
Thank you. Does the board have any questions?
None by me.
We have no questions. All right, so who's the applicant here to present this case?
Yes, Madam Chair. Okay, so it's yellow. We'll see. Wish me luck. Madam Chair, good morning. Stephen Anderson, Gammon Burnham. My address for your record is 40 North Central, 20th floor. I'm here today with Michelle Santoro, who is a land use planner from our office. And we are joined today by Sherwood Wang, who is the project architect. And I also want to introduce you to the landowners involved here. We're joined today by Dr. Otto Kupasamy, who's the gentleman in the scrubs for the chair. And also to his right is Dr. Dale Walk. Did I say that right? Walk? Yeah. Dr. Walk is Dr. Kupasamy's father-in-law. Dr. Kupasamy is the proud father of 5 children, including 2 3-month-old twins, and that will become relevant in a moment. I will get to that. We are seeking relief for the board. Oh, there I am. Yes, I did those introductions. It's working. We are seeking relief from the board for a residential project located in the Southeast Valley in the Queen Creek area. We're the blue dot on the map. In the staff remarks, Joseph just indicated, he's quoted you from paragraph 16 of the staff report, I believe it is, that sets forth a condition should the board see fit to approve this request. And we agree with that condition if the board does lean that direction. I wanted to bring to the board's attention a comment that is in paragraph 15 immediately before that from the staff report that says that the current property owners initiated the minor land division that resulted in the current substandard lot area. That is what is in the staff report. What the staff report fails to tell you is who told us to do that. The interesting thing about that is that they told us to do that. The county staff actually directed us to split the lot. They actually told us to create the condition. And here is their email of November 29 last year directing us to split the lot before filing the variance request. And now the implication, I guess, is that it's our fault that the lot got split. But we obviously think there's a little bit more to the story. And so that's the story that we want to share with you today. Let's actually, instead of starting at 2024, start at the beginning of the story. There we go. This is a slide, an aerial slide of the property in 1976. And back in 1976, of course, this was farmland. And what you see there in the lower right-hand, not the very lower right-hand corner, but or left-hand side of the middle left-hand side of the slide is the Vallis Homestead, sitting as what now is the southeast corner of Greenfield and Twin Acres Drive. In 2001, the lot splits began on this street. The north side of the street was split in September, and the Ballets split their south side of the street in November. So that's the September split on the north side of the street. This is the November split on the south side of the street. That happened 23 years ago. One of the basic tests for variance relief is whether the applicant created the situation that they seek to cure. Here, I am telling you that the Kupusamis showed up on this property more than 2 decades later after these lot splits began. Clearly, the pattern of development in this community is well established long before my clients become involved in the final development of the project. Now, note that in 2001, let's see if I can go backwards. I can, cool. The first split on the north side is 4 lots only, and the split on the south side is into 5 lots. So that's the south side, 5 lots. The reason for this is easy. The east-west distance of these properties cannot create 5 1-acre lots. They are just under 5 acres, and that is actually the property hardship. All you can do on this street is create 4 1-acre lots and 1 acre or 1 lot that is only almost 1 acre. In other words, the condition is inherent to the land itself, just as would be the case with a variance relief for a wash or a hill on property. By 2003, still more than 20 years ago, the first 5 houses are already in on the street, and as you can see, the development pattern for the street is already taking place of 1 acre and mostly 1 acre lots. Fast forward now to 2019, and that at the time has come for the north side of the Twin Acres Drive to build itself out. The owner files a variance request at the end of the street, because it's a dead-end street, to do exactly what the Kupusamis are seeking to do today. And the County Board of Adjustment in 2019 approves the variance. The reasoning for the variance then is the same as the reasoning as it is today. There is a hardship because the block is a tad short for 5 full 1-acre lots. The development pattern of the street gets set at 1-acre homes, which makes more sense than forcing a McMansion at the end of the dead-end street. Allowing a slightly less than 1-acre home at the end of the street actually preserves the continuity of the neighborhood rather than disrupting it. And so you get a streetscape that looks like this. The home gets built at the north end, at the east end of the street, on the north side of the street, in the blue box on the video, on the picture there. And it gives Twin Acres the appearance that it has today. I use the word appearance very intentionally. The appearance is of 8 1-acre lots existing there today. No one drives down Twin Acres Drive today saying, hey, that lot's not 43,560 square feet. That lot is actually only 40,000 square feet. They drive down the street and they say, wow, this is a nice street. Of course, the reality is that all of the lots on the street are in fact not 1 acre. In fact, according to the county assessor, of the 8 lots that exist today, half of them are under 1 acre. Let's state that fact. One more lot that is slightly less than 1 acre is not going to change the character of the community. It is going to be consistent with the character of the existing community that is there today. Now, the county is correct that there is a wrinkle to this story, and that's where we come now to the wrinkle in the story. In 2020, the prior owners of the 2 lots at the east end of the street, because there were 2 lots, chose to consolidate those 2 lots into one single jumbo-sized lot, with the idea that they would in fact build the incompatible McMansion on the property at the east end of the street on the south side. Then they changed their minds and decided to put the property up for sale and not develop the big house. That is when the Kupusamis finally show up, and they buy the lot more than 20 years after the original lot splits took place. So for 20 years, the property in question was shown and taxed as 2 separate lots, but for the past 4 years, it is accurate to say it has served as a single lot. So the Kupusamis want to restore the 2-lot condition of this land, that's why we're here today, and build 2 homes on roughly 1 acre lots, completing the build out of the street in a manner that's entirely consistent with what exists there today. By the way, now comes the time that we talk about the Kupusami kids. That's what this is all about. So the idea is they want to build 2 houses, one for the Kupusami family with their 5 kids, and they want to build a house next door where the in-laws can live next door and help take care of the big family of kids. But Mr. Walk, Dr. Walk, wants to go home at night and leave the grandkids at home next door. That is essentially why the Kupusami family is seeking to build 2 homes on this property as opposed to 1. I just wanted you to know the intent of the actual homeowner out in the real world. So the Kupusamis call us and they ask us what to do about this, and we tell them that they need a variance, just like on the north side of the street in 2019. And we filed that application last fall on November 16. Well, you now know what happened next. We filed that application and the county staff comes back and says, you can't do that. You actually have to split the lots first, then you can request the variance. We didn't necessarily agree with that, but we wanted to get the process going. And so we cooperated with the county staff and we did the lot split, which of course took some time and some extra money. Little did we know that it would then be used in the staff report in a way that suggests that we did something we weren't supposed to do. We believe the variance relief is appropriate here, and the relief, again, that is requested is exactly the same as was granted by the prior board in 2019. Now, of course, that board decision is not binding on you. You have the choice to do whatever you like today, but we like to think that the 2019 decision is persuasive to you. So moving to the variance test. Test 1, what is the peculiar condition? The peculiar condition here is that the subject land along the street is just under 5 total acres on each side of the street. That condition has now been compounded because the generation of development that has occurred over the past 20 years along the street creates a community of similarly sized lots. All of this predates the Kupusamis, so it is not a self-imposed situation. Test 2, is there a hardship? Well, the hardship now is that one lot along the street is being treated differently, potentially, than the rest of the entire street. The result could be one house that dwarfs the rest of the houses that are on the street. Note, by the way, that because this is the last lot on the street, there's no risk of precedent. This is the last one. There's no future landowner who's going to show up next month and go, well, you gave it to them, you have to give it to me. We're the last ones on the street. And test 3, what is the general intent of the zoning ordinance? Is this consistent with the general intent of the zoning ordinance? And we submit to you that the general intent of the zoning ordinance is to maintain compatibility and consistency. And in this case, the variance is essential to achieve that goal. If you deny the variance, you will actually create the incompatibility and inconsistency. So therefore, we are seeking your approval today for this variance, and we are happy to answer any questions that you have.
Does the board have any questions?
No,
No questions. We don't have any questions for you.
Thank you.
Thank you. Are there any, is there anyone from the public wishing to speak on this issue? Anyone online?
There's no one online wishing to speak.
Okay, no one from the public is here to speak, so we'll close the public meeting. I'll turn it over to the board for discussion or for possible action.
Madam Chair, Member, I would move for approval of BA 2024-013.
We have a motion from Board Member Loper for approval of BA 2024-013.
Second.
Have a second from Board Member Ward. So can we have a roll call vote?
Member Ward,
Aye.
Member Loper,
Yes.
Chair Clapp.
Yes.
Chair, we have a motion for approval by a vote of 3-0.
Thank you very much. We do have approval. Thank you. We'll move on to case number BA 2024-016, and that's also being presented by Mr. Mueller, correct?
Correct, Chair, thank you. BA 2024-016, the Bolos property. Next slide, please. The subject property is located on 109th Avenue in the Sun City area and is within the R16 zoning district. Next slide, please. The request is to allow a 4-foot interior side setback on the southern lot line where 5 feet is the minimum permitted. Next slide, please. Staff notes that the property is subject to an active co-violation case due to an unpermitted carport garage conversion. Historical aerial photos and images provided by the applicant indicate that the carport may have been extended into the setback area at some point prior to the current property owners taking ownership of the property in 2008. Staff was unable to find permit record of the carport expansion. Next slide, please. The unpermitted garage conversion did reduce the amount of the home that was within the side yard setback. However, the rear corner of the garage remains at 4 feet from the southern lot line. The property is relatively flat and is consistent in shape of those within the Sun City area. Next slide, please. If the board finds the applicant has satisfied the statutory test and has stated its findings on the record, the grant of this variance will memorialize a 4-foot southern setback line for APN 142-80212. Thank you. I'm happy to answer any questions.
Thank you. Does the board have any questions?
No questions?
None.
No questions. Thank you. All right, would the applicant please come forward, state your name?
Morning, my name is Richard D'Alessandro. I'm not the property owner, obviously. Apologize, I feel a little underprepared. I wasn't completely sure how the flow of this was all gonna go, so I don't have a PowerPoint or anything. I was just expecting to give the overview of what the situation is, which is more or less laid out for me. I could reiterate it and answer any questions. Yeah, so there was there was a carport existing. There was a closet in that carport. There's been some issues with trespassing in the area and on the property. So to better secure the property and address some issues that were going on with the current structure, the owner decided to have it framed in and make it more secure and better built. And that's what we did. There was obviously a code violation, and we have now we've worked with a drafter and an engineer. Engineer is ready to sign off on it. He's been to the property. We have everything ready for a permit. We were kind of waiting to see how everything turned out today before we went ahead with all that. Yeah, so also I'll reiterate, so the front of the now garage is 5 feet from the property, but there's the way the property sits on the street, there's a curve to the street, and it seems to sit on a little bit of an angle. So back by the gate, toward the halfway, I'd say halfway down the side of the property, there's a gate to the yard, and that's where you have the 4-foot issue. Other than that, the more you go forward toward the front of the garage, you have a wider and wider space, ultimately giving you the 5 feet at the front. And then the rear of the property, there's no issues. It sits further back. So hopefully that kind of explains the situation, and ready to answer any questions or anything.
Thank you, sir.
Sure.
Does the board have any questions for Mr. D'Alessandro?
I do not.
Mr. Loper? Apparently we have no questions.
No, no thanks.
Thank you, sir.
Yep, thank you.
Okay. Do we have anyone from the public that wishes to speak on this issue? No one online?
Yeah, there is no one online wishing to speak.
Okay, then I'll close this public forum. I'll turn it over to the board to make any comments or questions or make a motion.
Madam Chairman,
Yes.
I would like to make a motion to approve BA 2024016.
Thank you. Is there a second?
Second.
Okay, we have a motion by Board Member Ward, a second by Board Member Loper to approve BA 2024-016. Could we have a roll call vote?
Member Ward,
Yes.
Member Loper,
Yes.
Chair Clapp.
Yes.
Chair, we have a motion for an approval by a vote of 3-0.
Thank you. Thank you, sir. Okay, we'll move to the next case, which is BA 2024-019, 7025 North Long Look Road, LLC. And this is being presented by Nick Schlimm. Mr. Schlimm.
Thank you, Chair Clapp and members of the board. Case BA 2024-019 is a request to establish a 0-foot front and south side setback lines on the property owned by 7025 North Long Look Road, LLC, where 40 feet and 30 feet respectively are the minimum required. Next slide, please. So the subject property is owned Rural 43 and located in the Clearwater Hills Unit 2 subdivision. A single-family residence was developed on site in 2004. The owner is now proposing to build a basketball court and surrounding retaining walls within the front and south side setback areas in the southwestern portion of the lot. For background, the subject parcel generally corresponds with lot 171 of the subdivision, although the correspondence is not exact. The shared lot line between the subject site and its southern neighbor has been redelineated 3 times. In 2007, the then owner of both lots initiated a split combination in which the shared lot line was modified. This was done to better support development of a residence on the lot to the south. But consequently, the existing residence and pool on the subject site no longer met the required setback from the south lot line. The current owner took possession of parcel 169-13-933 in 2013, soon after he was issued building permits to remodel the residence to accommodate a relocated pool as well as existing development no longer in conformance with setbacks. The owner's agent submitted a variance application. Case BA 2014-054 had 2 requests. The first was to establish a front setback of 23 feet for the new pool, 10 feet for the existing retaining walls, and 0 feet for a new drainage system. The second request was to establish a south side setback of 10 feet for the retaining walls, 0 feet for the existing residence, and 0 feet for the drainage system. And prior to determination, the owners of the 2 properties cooperated on another lot split combination that added nearly 7,000 square feet to the subject site. The Board of Adjustment at the time approved the variance for parcel 169-13-933A. In 2020, the shared lot line was again modified slightly. The subject site received a net gain in area, about 1,600 square feet, although the residence on the lot to the south now appears to meet setback requirements as well. With this, the subject site became parcel 169-13-933B, its current parcel number. Staff notes that the variances approved per case BA 2014-054 are no longer valid because the previous parcel number is no longer active. The variances requested with this application, if approved, would supersede those approved in 2015. Next slide, please. Actually, previous slide. Thank you. After reviewing the request, staff is able to identify a peculiar condition of the lot. Steep hillside topography creates significant restrictions in where development is feasible without or with minimal disturbance of hillside areas. This pushes pragmatic site development toward the front of the lot proximate to the shared lot line with the neighboring lot to the south. However, staff cannot identify any requirement of the zoning ordinance that creates an unnecessary hardship. The existing residence was developed when the surrounding lot lines still matched those from the original subdivision plat. And furthermore, this residence has been developed without need for variance, which demonstrate that development of the original lot had been feasible without need for variance. Only after the south lot line was re-recorded by a previous owner was the residence brought out of conformance with setback regulations. And although variances to setbacks were approved in 2015, a subsequent re-recording of the south lot line voided both variances. Staff notes that since publication of the staff report, staff did receive 2 letters from nearby property owners expressing support for the subject variance requests. If the board finds that the applicant has satisfied the statutory test and has stated its findings on the record, the grant of this variance will memorialize items A and B. Item A states that variance approval establishes a 0-foot south setback line for all building structures and accessory recreational structures for APN 169-13-933B. I do want to call your attention to a minor typo as written in the staff report to item B. It currently references accessory residential structures. Item B should be written to state variance approval establishes a 0-foot west setback line for all building structures and accessory recreational structures for APN 169-13-933B. With that, I would be happy to answer any questions.
Thank
I
you.
have none.
Questions from the board? Yes. Board Member Ward, did you have a question?
No, I do not.
No.
Okay, we have no questions. So would the applicant please come forward and state your name?
Madam Chair, Ashley Marsh for Gamage and Burnham, 40 North Central, for your record. Thank you very much for an opportunity to address the board. Let's see if we can get into our presentation here. Again, Ashley Marsh with Gamage and Burnham. I'm joined today with Michelle Santoro, Senior Land Use Planner of our office, and the property owner, Mr. Hankels. We also have our summer law clerks in attendance, so happy to be here this morning and share a couple of key features about this property. Staff did a great job giving you a summary of kind of the long and tortured history of this project. The property is located in the Clearwater Hills subdivision in the Paradise Valley area of the county, northwest of Tatum and Lincoln Drive. And this particular subdivision, Clearwater Hills, was platted in the 1950s. The board's seen a number of variances for this particular subdivision because it is not only gorgeous, but it's very unique area in town with mountainous scenery and very hard to develop. So with that, you have a subdivision that's been platted in the 1950s that predates much of the zoning ordinance and the hillside ordinance up against some very mountainous conditions. So hard to develop in this area because of slope and drainage conditions. This map illustrates the different actions and requests brought before the board because of the nature and uniqueness of this particular subdivision in the hillside community. Okay. As we mentioned, the property outlined in blue is approximately 3 acres in size. However, development is really, really limited just to that western frontage. There is a small picture inset, and as you can see, the edge of the building envelope is basically built into the mountain, and the mountain goes straight up from there. So because of this condition, although it is a large property, 3 acres in size, only about 1/3 of it can be developed. And that's what's been built out along that western frontage because of the rocky terrain immediately adjacent behind the property. So per the hillside ordinance, everything outlined in blue on this particular area, that blue hexagon shape, for lack of a better description, and my 3-year-old would be disappointed in my shapes, but that's what would be the buildable area per the hillside ordinance. As you saw in that inset in the previous slide, although buildable per the ordinance, not buildable in reality because it is a straight up 35% slope. So you have, can't go forward here. You have a condition where that property is simply undevelopable per the hillside conditions and the drainage patterns in the area. You physically cannot build up, you physically have to build out. So staff did a great job going over the summary of this particular lot and the various lot splits and lot lines that have developed over time. And I'll quickly go through just to put a visual on those because it does sound more expansive, but they've all been necessary to develop this lot in conjunction with the adjacent lot. So here's an aerial, historic aerial from 2003, and you can see the beginning of the building on this specific lot up towards that western frontage. This is how the lot was originally configured in 2003 and met the setbacks at that time. The first lot line adjustment happened in 2006, and that was to accommodate lot 172 to the south of us. And as you can see, there was a little bit of an inlet, for lack of a lack of a better term, to expand a little bit of this square footage of long 172, because again, with these properties, you have to build out, you cannot build up because the hillside condition immediately back of these homes. So as part of that lot line adjustment, the property of 172 got a little wider at the base of the mountain, as did our property. And you see there's a little bit of acreage outlined in blue there that was added per easement in 2015. So that's already disturbed area, and variances were applied for at that time. 2015, again, you see now that disturbed area is built out along that western frontage, and landscaping was added to that western perimeter. There was a pool in this area that actually had to be relocated because there was a crack in that pool, and additional drainage mitigation needed to be performed. So this disturbed area pool needed to be relocated, and variance was obtained. Again, in 2020, there was a subsequent lot line adjustment, and that was to accommodate additional drainage off the mountain. So you see in the hatched area, a variance was obtained again to accommodate that drainage and to allow these two properties to develop in unison, because again, you have to develop out, you can't go up. So here we are seeking an application to reduce the side yard setback and the front yard setback to 0 feet to accommodate a sports court. And the area, which I'll show you in the next slide, is really in that 2015 easement area that was later codified as part of the lot split. So it's already disturbed area. Another justification for the variance is that you don't want to disturb undisturbed area. We're trying to develop within the building footprint of already disturbed area and what would be a buildable footprint. So as you see in this slide, there is this proposed sports court. Obviously the site plan is there, and the blue hatching you can see is just a little bit of that frontage, and a little bit of the side yard would be built out to accommodate that sport court, and thus inspiring the request for the reduced setbacks in this area. Again, there is no feasible way to take advantage of the 75,000 square feet of buildable area under the hillside ordinance, because you can't go up. There's 35% slope. The building is already pressed up against the mountain as far as it can go. In conjunction with the construction of lot 172, 171, there have been some lot light adjustments. And again, that is just to make sure that the slope and drainage are accounted for in this really unique but very mountainous area. So with that, the peculiar conditions of the property do create an unnecessary hardship that's not self-created in the line of title, because irrespective of any of those lot line changes, again, you simply can't build up, you have to build out. And that's true for our property and most in this area. The lot lines were adjusted multiple times to constraints of the hillside, and the extreme slope is a hardship not created by any property owner. No one created that hill that goes at a 35% slope. As I had mentioned, under the ordinances, Mr. Henkels is entitled to build up to 75,000 square feet of disturbance, and there's nowhere to actually use that, thus the variance is necessary. And granting the requested variance would not cause a negative impact on the general intent or purpose of the zoning ordinance. Quite to the contrary, we do have 2 letters of support from neighbors, and the strict application of the variance, of the ordinance necessitates a variance, because the strict application would prohibit any type of building out and essentially causes 2/3 of the property to be completely unusable. So I'm happy to answer any questions. We appreciate the board's consideration and would respectfully request that these 2 variances be granted.
Thank you. Are there any questions from the board?
I have none.
I have none.
We have no questions. Thank you.
Thank you, Madam Chair.
Do we have any members of the public that wishes to speak, either here or online?
There are no speakers online.
Thank you. Then we'll close the public forum. I'll turn the case over to the board for discussion or a motion, if you prefer. Yes.
Madam Chairman,
Yes.
unless anyone has any discussion, I would like to make a motion to approve BA 24019.
Thank you. Is there a second? We have a motion from Board Member Ward, a second from Board Member Loper. Can we have a vote, please?
Member Ward,
Yes.
Member Loper,
Yes.
Chair Clapp.
Yes,
Chair, we have a motion for an approval by a vote of 3-0.
thank you. Thank you very much. Next case for consideration is TU 2024027, Red Hot Fireworks Tent Sale. And again, we'll have a presentation from Mr. Schlimm.
Thank you,
Thank you.
Chair Clapp. Case TU 2024-027 is a request for a temporary use permit for seasonal sales. Next slide, please. So the subject site is zoned C2 CUPD SUP and is located approximately 750 feet east of the northeast corner of 7th Street and Carefree Highway in the North Phoenix Desert Hills area. The property is approximately 5 acres and was recently vacant, though most of the east half of the property has been developed with an RV and boat storage lot, an extension of an existing use on the adjacent property to the north. Presently, the west half of the property remains vacant, and it is in this area where the seasonal sales tent would be located. The applicant is requesting this TUP to allow a fireworks sales tent on site. The applicant's company, Red Hot Fireworks, would sell fireworks to the public in compliance with state laws in advance of the Independence Day holiday. Sales would begin on June 21st and would end on the 4th of July, after which the tent would be removed from the site for this season. This TUP would be the 6th such request on the subject lot. Similar requests for fireworks sales in advance of New Year's Day and Independence Day have been approved since December 2021. The current request is essentially identical to the previous 5. Hours of operation be from 8 a.m. to 10 p.m. daily. Sales would take place under a 30-foot by 70-foot tent, and merchandise would be securely stored overnight in an 8-foot by 40-foot metal storage container. Nighttime lighting would be provided by a mobile light tower with a self-contained generator, and customers would be limited to a maximum of 50 individuals at once. Staff received 1 notice of opposition, which expressed general objection to a street side vendor selling fireworks to the public. This notice expressed concern that the potential for property damage or loss due to mishandling of pyrotechnics was not being sufficiently considered. Nonetheless, staff believes that the applicant has satisfied the requirements of the zoning ordinance regarding temporary seasonal sales. Had no opposition been received, this TUP would have been approved administratively. As previously noted, near identical requests for seasonal fireworks sales have been approved on the subject site 5 times previously. 4 of these requests received no opposition from the public and were approved administratively. 1 other request received a notice of opposition from the public, but received staff's recommendation of approval and was approved unanimously by the board. With this, staff recommends approval of TU 2024-027, subject to the conditions of approval outlined in paragraph 19 of the staff report. At this time, I would be happy to answer any questions.
Does the board have any questions? We have no questions. Thank you. Okay, would the applicant please come forward? State your name, please, and address.
My name is Karen Herman with Red Hot Fireworks. I'm one of the owners, and our address is 25617 West Quail's Nest Lane.
Go ahead.
In Whitman, Arizona, sorry. Well, thank you for hearing this today. I appreciate the time of the board members. We've actually been on this location, not on this particular spot, but right next door for 11 years. So we've been there quite a long time. Can you go to the next slide? Nicholas has already addressed most of the information on our narrative here, so I won't waste time doing that again. But the time slot that's indicated that we're requesting from the 21st of this month through July 4th is legal in the law that was passed here for the state of Arizona to be able to sell fireworks. Next slide, please. This slide just shows where we are at now. We were on the west bottom corner there for many years, but we've been at this slot now for about 6 years, and have been approved, like Nicholas had mentioned. Next slide, please. We've already applied and received our permit from Daisy Mountain Fire. So we have a very good standing relationship with them. They come out and inspect the tent and we pass every time because we do follow what they call NFPA 1124 and all the guidelines that we have to follow through that they set down. Next slide, please. Oh, this is it, correct. This right here, I put in here because this shows the bill, the state law. You would see that the second arrow down, since Maricopa County has the 500,000 above that level, then we follow this particular section. And there again, it states the NFPA 1124 guidelines that we must follow. And then the county can tell us exactly what days other than the days that are indicated in the state. And we fall within that for the 4th of July timeframe. And again, we'll apply for New Year's. Next slide, please. I went ahead and put this slide in here because the nature of the complaint or the concern was that in our tent, we were selling, I guess I want to say that they were thinking illegal fireworks, but we do not. Again, we follow everything that's dictated down per the state law. We sell what was called at the bottom of this page, it says safe and sane fireworks. We sell the novelties and we also sell smoke devices. So anything that you see that goes into the air, that's illegal and we do not sell that. And that's what causes a lot of concerns for the citizens is that they see things going up in the air and exploding, and then they're hearing the loud explosions on the ground. All the fireworks that we sell, they do not contain explosive composition. All of ours are just sparkles and smoke, okay? So that's the reason why I put this in here so people would understand that, because they get a little confused. Next slide, please. And again, on our website, we state even part of our mission statement, safe and sane fireworks. We do everything by the law because we've been in business since 2010. We want to continue to do business here in the state of Arizona, so we would never want to risk that by doing anything outside the law. Next slide. And I went on to one of the top retailers of fireworks in the nation is TNT Fireworks. And they have a corporate division that goes out and talks to the Fry's and the Walmarts and the Sam's, all of the big retail chains. And so they sell fireworks in store. So when you go in to buy your groceries, you're going to see TNT fireworks sitting there. Those are the same fireworks that we sell in our tent as well. So this map right here, the X, if you can see it, the blue X towards the top, that's where our stand would be located. Not more than a mile down the road is the Fry's, and they're selling fireworks inside the store and also out on their parking lot. And over to the west, where it says number 4, that's the Albertson store. And they actually sell fireworks in store. And the rest of those numbers indicate all the other places around this particular area that sell fireworks. And some of those retailers are like I mentioned before, Walmart, Fry's, Bash's, Target, Safeway, Albertsons, and many other retail locations throughout the valley. And a lot of them sell in-store and also out in the parking lot, just like what we do outside. And next slide. And just to sum it up, we're just a small family business that follow the laws here in Arizona while trying to make a living. So we would appreciate your approval. Thank you for your time.
Thank you. Are there any questions from the board for the applicant?
No.
I do
No
not.
question for you, ma'am. Thank you. Do we have anyone from the public that wishes to speak either here or online?
There is no one online wishing to speak.
Thank you. Seems to be nobody wants to speak on this issue, so the public forum is closed. I'll turn this over to the board to discuss or make a motion.
Madam Chairman,
Yes, board
I-
member Ward.
thank you. I would like to make a motion to approve temporary use 2024027. I should have made that sounding like I was going to stop right there. I would like to make a motion to approve temporary use permit 2024027.
And I second that motion.
Okay, and that is subject to the conditions in the report A through E, correct?
Yes, thank you.
Okay, thank you. A through G, I'm sorry. Okay, we have a motion and a second to approve TU 2024027. Could we have a roll call, please?
Member Ward,
Yes,
Member Loper,
Yes.
Chair Clapp.
Yes.
Chair, we have a motion for approval by a vote of 3-0.
Okay, thank you. Thank you for coming. We have no other matters on the agenda, so I will adjourn the meeting. And note that we do have a session, so please stand by because we have another session after this that's executive session.
Madam Chair, I'm sorry. Council's asked, could we reopen the hearing and have a vote to go into executive session?
Oh, sure. Happy to do that. I'll reopen the meeting. Everybody's still there, hopefully. We need a vote to go into executive session. Roll call.
Member Ward,
yes.
Member Loper,
Yes.
Chair Clapp.
Yes.
That's a motion to move forward with the executive session by 3-0.
Okay.
David,